No, first of all, given the local antipathy to initials, just so we're clear, PJM stands for Pennsylvania, New Jersey, and Maryland, correct?
It does,
Yeah.
although the region now expands quite a bit outside of those 3 states.
Those were the original 3 states in PJM?
Correct.
All right. We'll get past that one. One of the other aspects I want to ask you about very quickly are benefits of a plant like this one. Do you know what ramp rate is?
Yes.
What is ramp rate?
Ramp rate is a measure of the amount of megawatts over a certain period of time that a plant can increase
We're not
its
going
capacity.
anywhere. As you can see.
Is that also known as spinning reserve?
Support. Have a good day.
A plant's ramp rate, to the extent that it's sufficient, would allow it to provide spinning reserves.
All right. Could you provide more of an English explanation of what those two concepts are?
Yeah, so ramp rate would be defined in the, usually defined in the amount of megawatts per hour. So if a ramp rate is 200 megawatts an hour, that means it can increase its capacity by 200 megawatts within a given hour. Spinning reserves.
Sorry, what are you saying? Spinning?
Spinning. And then, yeah.
I heard spinning, and I just...
Spinning.
Thank you for clarifying. Spinning reserves is an element of the market, an ancillary product where power plants are essentially on standby to increase their capacity, typically within a 10-minute period. There's a 10-minute product and a 30-minute product. So the market will look at its requirements, and they have so much 10-minute spinning reserve that are required and so much 30-minute spinning reserves that are required. So that just means it's on call to increase its capacity within that time frame.
And are you aware that Clear River can offer 50 megawatts per minute per train of spinning reserves?
That sounds right. I'm not an engineer, but we typically rely on the engineers to provide us with those metrics.
So in terms of spinning reserves, Clear River would be able to offer 100 megawatts per minute?
That sounds correct.
That's all I have. Thank you.
Did you say train?
Turbine.
Per turbine.
Thank
Yes.
you.
I think I got some questions.
Okay.
Assuming it were to participate in for capacity auction 14 or initially in any later auction, would Unit 1 have to bid as an existing or a new?
It would bid as a new resource.
So after being disqualified, it goes back because it never actually provided any capacity, so it never loses its newness.
It's new unit status. I believe that's correct. Yes.
Going back to the 7-year price lock concept, if a facility, always a new facility, opts into a 7-year price lock and clears in an initial capacity auction, are there any restrictions on what options the facility has for temporarily or permanently exiting the capacity market during auctions 2 through 7?
It's a good question. I believe to the extent that they would want to exit future auctions, they would have to follow a similar process as other existing assets. So they would have
So
to,
that's the same delist and retirement options.
I believe so.
Okay. I think that's it. Any question?
I'm sure there's some more questions, so I may have a couple, but I think I'm going to wait until, and I seem to be just interrupting and asking along the way too, comfortably.
Everyone has an absolutely superb question.
Well, you know what, I'm going to second that, not as false praise, but personally to me, but to me, when I'm going along and asking a question, I think it works better if the board members ask their question while I'm on that topic. For me, and I don't consider it an interruption at all. So just for the record.
All kidding aside,
Thank you.
I really do agree, and I wasn't kidding when I said before, one of your questions got rid of an entire page of mine. So please don't hesitate.
I would agree as well.
Thank you, Chairperson. Mr. Hardy, Mr. Glazier started his redirect by asking about air emissions, and you testified, and let me just pause for a moment. I made notes on some things you said. Some will be paraphrased, some will be quotes. If I get a paraphrase or a quote wrong, please correct me. I'm not trying to put wrong words.
Sure.
You testified, this is a paraphrase, that you had done your work on air emissions based on an economic analysis. Is that right?
Correct.
And you said you were assuming that the facility would be operating when it was economic to do so. Is that right?
Correct.
And you've estimated or believed that that would be about 60 to 65% of the time.
That's what I recall, yes.
And then you explained that a resource like Invenergy or another one would be permitted to participate in the energy market without a CSO. Is that correct?
A resource can operate or participate in the energy market without a CSO. That's correct.
And then you said, quote, in that regard, the energy market is separate and distinct from having a CSO, unquote. Is that right?
I'm not sure if that's a quote or a paraphrase, but that sounds correct, yes.
But there is the following distinction between in the energy market between a resource with a CSO and a resource without a CSO. And that distinction is that only the resource with a CSO is subject to the ISO's must-offer rule. Is that correct?
That's correct.
And the must-offer rule provides that if a resource has a CSO, it must offer energy into the real-time energy market every one of the 8,760 hours of the year. Is that correct?
Day ahead, I believe, or real time, yes.
Well, which is it, day ahead or real time?
Well, New England is a dual settlement market. You can offer your capacity into your energy into the day ahead market. The day ahead market is a financial commitment to offer your energy. The only difference is whether or not the price you receive for your energy is day ahead or real time.
Yes, you're correct that ISO New England offers both a day ahead and a real time market. And it's true that over the last 12 months, ISO has cleared between 97 and 102% of the real time.
I'm sorry, is that a question or is that testimony?
Here's a question. My question is,
I object. That's not a proper question. Mr. Elmer can testify.
does the must-offer rule apply to the day ahead or to the real-time energy market?
I believe it applies to the real time energy market.
And it does not apply to a resource that doesn't have a CSO.
That's correct.
So a resource without a CSO can make an election in every hour of the year as to whether to offer into the energy market or not. Is that correct?
That's correct.
In your expert opinion, do you believe that resources in New England would make that election based on the economics of the real-time or day-ahead clearing price for energy?
Is the question either or in or both?
Is it your opinion that resources in New England will make the decision whether to offer in? Let me start again. We're discussing a New England resource that has no CSO.
Okay.
And we've just established that it may offer into the energy market if it wants to, but it's not obligated to.
Correct.
Do you believe that a resource will make that decision based on economic factors?
Absolutely.
Mr. Glazier, in response to a question from Mr. Glazier, you said that, now switching topics, to the disqualification by the ISO of turbine 2 for FCA 12.
Okay.
It's good. I got a little confused maybe because it's afternoon. So can I just verify what you just said? The must offer is applicable to a facility with a CSO in the real-time market. Is that what you said?
Correct.
And then you said a facility without a CSO could participate in the day ahead.
Day ahead in real time.
And real time, and they would do that based on economic factors.
Yes. I mean,
Did I miss something? I just want to make sure I understood.
I think that, in my view, and I don't want to put words into your mouth, so you correct it. I think the difference here is a plant with a CSO has an obligation where they have to offer their energy into the market and participate in the real time. Oftentimes, most of their energy that they offer in is going to clear in the day ahead. The only difference being the day ahead is just a financial commitment. Ultimately, they're going to, if they're called on, they're going to operate in the real time. But even with that obligation, ultimately, how many hours or how much energy a facility produces is primarily a function of economics. They're going to offer their energy in based on what their variable cost to produce that energy is. If the prevailing price is lower than that, they won't get called on. A plant without a CSO and without the obligation to participate in that real-time market, if they are taking a profit maximizing position, would operate in very much the same way. They will offer in their energy based on their variable cost, and they'll get called on if the price exceeds that. Yeah.
So we're now talking about the ISO's disqualification of turbine 2 from FCA 12. And in response to a question from Mr. Glazier, you said that you did not know of the disqualification before it occurred. Is that correct?
That's correct.
The disqualification occurred in late September of 2017. Is that correct?
That sounds correct.
And in mid-September of 2017, you submitted testimony reflecting your belief that turbine 2 would clear in the upcoming auction. Is that correct?
You're talking about my second supplemental on
The September 2017 testimony.
September. That was September 1st of 2017,
Okay.
the rebuttal testimony. That's correct. Yeah, that was submitted on September 1st, 2017. So my analysis that went into that, my testimony, yes, that was, my assumption at that point was that Craig was that Unit 2 would be allowed to participate in FCA 12. That's correct.
No, yes, okay. You pointed out in response to questions from Mr. Glazier that a number of power plant owners, including Coach Energy and Exelon, would like to see FCA clearing prices higher because that could benefit their companies if they have new entry into the market. Is that correct?
I believe what I said, and I was initially, in what I referenced in my testimony, was specifically comments from Coach Energy that they had filed as part of the process when ISO New England was considering terminating Clear River Unit 1 CSO. And their comments to the ISO were that the presence of Clear River clearing the auction was suppressing the price when in reality the plant would not be operating in the market. It's my opinion that the reason that they made those comments is because they own generators in the market, and all else equal, it would benefit them if capacity prices are higher.
So all else being equal, it benefits generators if capacity market clearing prices go up.
Yes.
And so these generators have an economic interest in seeing that happen.
Correct.
Conversely, ratepayers benefit from capacity prices falling. Isn't that correct?
Yes.
And it's ultimately the job of the ISO to run a fair market that balances the needs of those who would like capacity clearing prices to go up and those who would like capacity clearing prices to go down. Is that right?
Exactly, and that's what we talk about when we make reference to maximizing social surplus. That's essentially taking into account consumer and producer on both sides.
And then Director Coyd asked you whether she had understood you correctly, that in recent years, supply of capacity in New England has been increasing while demand has been decreasing. Do you recall that?
I believe the question that was asked was, are the decreasing capacity prices as a result of supply increasing? And my answer was, that's part of it. Part of it is that supply is increasing, and part of it is that demand has decreased.
And that, in fact, was what you were referring to here at the preliminary hearing on January 12th, 2016, when you described the energy and capacity markets as being dynamic and changing from time to time. Is that correct?
That's certainly part of it, I guess, yes. I mean, there are aspects of the market that impact both capacity and energy that are changing annually, if not monthly, if not hourly.
I'm going to ask you a few questions about the email that Mr. Glazier asked you about, which is a part of Invenergy Exhibit 151. And you can certainly answer my questions at as much length as you want, but I'll tell you that all of my questions, except one where I ask you to read a sentence, they can all be answered by yes or no, but feel free to answer at great length as you like. This is an email that you sent, is that correct?
If you're talking about the email dated October 4th from myself to John Nyland, Ken Parkhill, and others?
Yes.
That's correct.
And Mr. Nyland and Mr. Parkhill work for Invenergy and have Invenergy email addresses?
Correct.
And then you sent the email as well to two people at PA Consulting?
The two people at PA were CC'd, that's correct.
Yeah. And you wrote this email?
I did.
And could you read slowly for the stenographer the first sentence of the first indented paragraph?
Based on our experience before the Rhode Island EFSB and NTE Killingly's experience before the CT Connecticut Siting Council, it appears that the applicable state permitting boards are unlikely to approve the construction of new natural gas plants without having secured a CSO through an FCA.
At the time you wrote this email, October 4th, 2017, Did you believe that statement to be true?
No, I believe, as I described, the purpose of this email was to provide Mr. Nyland with talking points to discuss with the ISO. Certainly, this is an issue that was faced by Killingly. It's a potential issue that's faced by Clear River. This is not my opinion. These are talking points that were for Mr. Nyland to have a discussion with ISO New England. Him as the developer of a power plant, and ISO New England as the market operator for New England.
When you sent this email, did you have an expectation that you would be cross-examined about it at this proceeding?
I didn't have an expectation that I would be cross-examined about this email in particular, but I knew that we were in a process where certainly that any of my communications with Mr. Nyland could certainly be part of the record.
And at the time you sent this email, Invenergy was a client of PA Consulting.
They were a client at that time, and they're a client today.
And it's your sworn testimony here today under oath, under penalty of perjury, that at the time you wrote this email, you did not believe that sentence to be true.
Yes, I believe I answered that, and that is true. Again, I will say for purposes of everybody in the room, these were created as talking points. If you see the indenture, it says Q with a parens, that is question. So these are questions that Mr. Nyland could bring up with the ISO.
Is there a question mark at the end of that sentence?
There's a question mark at the end of this entire paragraph, yes.
Could you read back the pending question, please?
Is there a question mark at the end of that sentence?
At the end of what sentence?
Based on our experience before the Rhode Island EFSB and NTE Killingly's experience before the CT Siting Council, it appears that the applicable state permitting boards are unlikely to approve the construction of new natural gas plants without having secured a CSO through an FCA.
There's a period at the end of that sentence.
Thank you. I'm going to direct you to the last paragraph of the email. And as a preliminary, we will explain the acronym IMAP that appears in the last sentence. Am I correct that IMAP stands for Integrating Markets and Public Policy?
I believe that's true.
So the first sentence of this paragraph says the integration of new resources subsidized by state-level policy initiatives is having a downward impact on capacity pricing. Is that right?
That's what it says, yes.
When you wrote that sentence, did you believe it to be true?
No. Again, all three of these questions are talking points for a meeting between Mr. Nyland and ISO New England. And these are written, if you look at the questions, they're written as to be asked from Invenergy. These are not questions that I am asking of anybody on the email. These are questions provided to him as background for a meeting.
So, Mr. Hardy, just to be clear, you do not believe that is true? That integration of new resources subsidized by state level policy initiatives is having a downward impact on capacity pricing?
I think there's the potential that can happen, yes. Has it happened to date? I don't think it has. I think this is certainly something that could happen. I mean, to the extent that you have large off-scale offshore wind projects or large transmission projects that are subsidized that come in, it really, and we kind of talked about this earlier, it kind of depends on how the forward capacity auction ultimately treats these megawatts. So is it a possibility? Absolutely. Was this my belief at that time or my belief today? No, these are talking points for a discussion between a developer and a system operator.
And in the talking points, you're essentially just offering some concerns or queries that might be raised by any or all NEPOOL members.
Yes, I think primarily there would be concerns that would be raised, by a developer that's saying, look, this is how we see the process, what are you doing about it, type of, that was kind of the overall discussion, and in my view, that was the nature of the discussion, and so that was the talking points that we provided for that.
And the last sentence of this paragraph says, has ISO New England considered, you probably mean considered, expediting the IMAP process to minimize the influences of out-of-market subsidies on the competitive markets, question mark, right?
Yes.
And the IMAP process was a fairly lengthy process undertaken by the New England Power Pool in connection with the ISO.
I believe that's true, yes.
And the ultimate outcome of the NEPOOL IMAP process was a filing with FERC, which you referred to earlier in an answer to Director Coy. You said you didn't want to go down the rabbit hole of the substitution auctions. Is it true that the outcome of the IMAP process was a FERC filing pertaining to CASPR, which is an acronym, CASPR, for competitive auctions with state policy resources?
So I missed what the question is.
Was the ultimate outcome of the NEPOOL and ISO IMAP process a filing with FERC pertaining to CASPR, competitive auctions with state policy resources?
So I'm well aware of the CASPR process. I'm not positive if CASPR, the filing around CASPR was an immediate outcome of the IMAP process. I'm just not sure.
But the CASPR process provides, as you said earlier, for a substitution auction. Is that correct?
Yes,
To be conducted after the primary FCA,
that's correct.
to facilitate the exit from the market of dirty old fossil resources and the entry of clean new renewables. Is that correct?
I'm not sure I would characterize it that way, but the substitution auction is a process by which new renewable generators that are entering based on a state policy or state subsidized process can be substituted for capacity that is looking to retire the market.
And is it your understanding that that capacity that's looking to retire the market would be dirty old fossil generation?
I think the capacity that's looking to retire the market would probably be capacity that is uneconomic and or sees the ability to exit the market at a price that is economic for them to do so.
And do you believe that that would be dirty old fossil generation?
I mean, those are adjectives. I'm not sure. I would think it would be older. In some cases, capacity that is older or higher emitting could be for sure. It could be any facility that considers itself uneconomic. I don't consider the Connecticut nuclear facility to be dirty and old, but yet they were looking to exit the market absent subsidies. So.
But part of CASPR is to pay a financial bonus to those older, higher emitting facilities that elect to leave the market. Is that correct?
It the part of the process is meant to compensate them at the level that new renewables are entering the market. It makes no mention of those other terms.
So the substitution auction is designed to facilitate the entry of state-sponsored renewables, is that correct?
Correct.
And facilitate the exit, in your words, of older, higher emitting resources, is that correct?
In some cases, yes. It's not limited to older, higher emitting resources.
I thought I thought that was your characterization, that I said dirty old fossil generation and you said no, older, higher emitting.
I said it could be older, higher emitting, but not limited to that.
Let's look at your December 14th testimony, if we can call that up on the screen, looking at page 14. I'm looking at page 14, lines 2 through 4 or 5. And take this slowly because it can be confusing, but you testified in response to questions from Mr. Glazier that CREC Unit 1's capacity contributed to lower capacity prices in FCA 10 and 11 than if it had not participated. Is that right?
Correct.
And FCA 10 was conducted in February of 2016. Is that correct?
Correct.
FCA 11 was conducted in February of 2017, is that correct?
Yes.
And it's true that nothing that this board can do by either granting or denying a permit will have any effect on the impact that CREC's Unit 1 had in FCA 10 and FCA 11, because those auctions are done and over. Is that right?
That's correct. I think it's just an example of the impact or potential impact of Clear River in the market.
So if this EFSB grants Invenergy's permit, the price effect in FCA's 10 and 11 will not be changed in any way at all, will it?
That's correct.
And if the EFSB denies the permit, that action will have no effect on the impact that CREC had in auctions 10 and 11, right?
That's correct.
In fact, nothing that this board does with regard to granting or denying a permit will change those price impacts because those are already baked into the system. Is that right?
Correct.
So those specific price benefits cannot be argued as a reason for granting the permit, can they?
No. Again, I think that it's just a real-world example outside of any calculations or forecasts that show the potential impact or the impact of ratepayer savings.
And then you were talking about the price effects of forward capacity auctions that will get felt in the future because the FCA is a 3-year ahead market. Do you recall that?
Yes.
So there was a very high clearing price in FCA 9 in this zone, $17.73, if I believe.
Correct. Yep.
And because that was a forward market, a forward auction, that effect is being felt by ratepayers today, because this is the capacity commitment period.
Absolutely.
And then you used the analogy, you said it was like the polar vortex, which occurred 1 year, and then there was a price effect in a future year. Recall that?
That's correct.
But the difference between the polar vortex effect, the FCA effect, is that one is in energy and one is in capacity, right?
That's correct.
So that's an imprecise analogy, would you agree?
No, the analogy was to say that to the extent that there are impacts on capacity or energy markets, those have a meaningful impact on consumer rates.
Director Coit asked you some questions about your analysis of what would have happened here without the participation of Invenergy in FCA 10, and I'm not sure that I understood your answer. Was your answer, I think Director Coit asked that there were two different ways that you could have accounted for the absence of Invenergy in the auction. One is to take out the 485 megawatts that actually cleared and walk up the demand curve by 485 megawatts and see what the new clearing price would be. The other way of approaching it would be to assume that another competitor entered and cleared 485 megawatts, but Invenergy didn't. Do you recall that?
I do.
Which did you do?
So we evaluate the market with and without Clear River. So depending on the year, it could be that there is capacity that replaces Clear River or not. I believe in this case, subject to check, the impacts on FCA 10 and 11 from a capacity market standpoint were based on the capacity price with Clear River and the capacity price without.
So you basically walked up the demand curve, 485 megawatts, looked to see what the new clearing price would be, and then multiplied it out and came up with your figure.
I'm not sure it's that simple, but at a high level, that sounds correct.
And if that methodology weren't correct, then your result would also not be correct.
If the methodology were not correct.
Right. If you did not, you assumed, for purposes of your analysis, that there was no other capacity to fill that need. So you just walked up the demand curve, 485 megawatts. But if that assumption about the absence of new capacity was mistaken, your conclusion would also be mistaken.
To the extent that there is other capacity that would enter the market at a different price than what I ultimately calculated, then the numbers would be different. That's correct.
Okay. In response to questions from Mr. Glazier, you discussed the ancillary services market in New England. Is that correct?
Yes.
That, just to be clear, ISO New England runs a capacity market and an energy market and an ancillary services market. Is that correct?
Yes.
Isn't it a fact that the ancillary services market accounts for substantially less than 1% of the dollar value of the three markets run by ISO New England?
I'm not sure if it's less than 1%. I would agree that the dollar value associated with ancillary services in general is much smaller than energy and capacity. I can't verify less than 1%.
Do you have an expert opinion as to whether a generator like Invenergy could be financially viable in the ISO-run markets without capacity payments, relying on the ancillary services market?
There are generators that operate in New England and other markets that rely primarily on ancillary services. Whether or not Invenergy could or would is a function of how they plan to operate their facility.
Invenergy proposes a 1,000 megawatt gas combined cycle plant. Is that correct?
Yes,
With a very modern GE H series turbine,
that's correct.
fueled most hours of the year on natural gas and some hours of the year on diesel fuel.
Yes, our projections indicate majority, if not all hours, would be on natural gas, but they have the ability to run on oil as well. That's correct.
Do you believe that the income from the ancillary services market could be a material part of the Invenergy balance sheet operating a 1,000 megawatt gas CC unit in New England?
How do you define material?
Material means that the presence or absence of that factor can have an effect on the outcome. Outcome could be different depending on that factor.
Certainly the outcome could be different with and without ancillary services. I think more of their revenue will be driven by energy and capacity, in my opinion.
And you stand by your testimony that you cannot confirm that the ancillary services market is less than 1% of the dollar value of the ISO run market.
Yes, that's the answer.
Let me ask a different question, which I think is, in your expert opinion, would it make sense to build $1 billion plant without the anticipation that you would be participating in the FCA, clearing the FCA and participating in that market?
I think the plant could be constructed without clearing an FCA, but I think if you look at the economics over a lifetime of the plant, certainly the plant is likely to require capacity revenues as part of that equation. I think that's fair to say, absolutely.
To your knowledge, Mr. Hardy, are there ever, when you talked about plants that are participating in the ancillary market, are they, has there ever been an instance where a plant was constructed and then only participated in that small market? Or are those plants that are already existing? Maybe you don't know.
Maybe I could answer it this way. For a combined cycle plant, I don't think you would construct a combined cycle just for ancillaries. There are certainly existing plants that oftentimes participating in ancillaries is actually a trade-off to the energy market. So there's that opportunity cost of offering energy or holding back some of those megawatts. So the price of energy and ancillaries could determine that. So any given year you could shift between them, but Mr. Elm is right. The ancillary market is absolutely much smaller. Whether it's 1% or 2%, I couldn't say for sure, but it is a lot smaller.
You testified in response to a question from Mr. Glazier that a resource such as Invenergy is allowed under the ISO tariff to participate in an annual reconfiguration auction without having a CSO. Is that right?
That's correct.
What you mean is, because of course Invenergy participated but sold out of its CSO, what you meant is that a resource is permitted to offer capacity into the ARA without having a CSO.
Correct.
It's also true, isn't it, that the ISO qualification process for being allowed to offer into an ARA is identical in every respect to the qualification process for participating in a primary auction.
My understanding is it's very similar. Whether it's exactly the same, I can't say for sure.
Along those lines, is there any, if there were a scenario where the plant were licensed and then went back under your your last testimony says you expect it to clear in SCA 14. Is there a different, is it just the same qualification process and they just start from square one again? Or is there anything unusual given the trajectory this has gone?
Yeah, no, I understand the question. I think it's much the same process. Yeah.
Mr. Glazier asked you some questions about the Millstone, Connecticut nuclear plant. Do you recall that?
Yes.
And in one of his questions, Mr. Glazier used the word, quote, subsidy, unquote. Do you recall that?
I do.
And you corrected him and said that Millstone was going to get compensated for its clean energy attributes. Is that correct?
That's correct.
And that is your understanding, isn't it?
It is.
In much the same way that Invenergy's wind farms in various parts of the country receive compensation for their clean energy attributes. Is that right?
It's not necessarily the same process. I guess you would have to tell me a specific plant, a specific market, and I can tell you how similar it is.
Is it fair to say that different FERC-regulated ISOs in the country, New York ISO, ISO New England, PJM, MISO, provide different mechanisms to compensate resources for their clean energy attributes?
Well, in the case of Millstone, it's really not being compensated at the ISO level. This is really something that's being driven at the state level. So every market, every state is a little bit different, and they're trying to solve different issues and different problems. So it's hard to make generalizations across different states or different markets. In this particular case, in the case of Connecticut, Millstone was at risk of retirement based on competitively operating in the market. They indicated that they were losing money and were going to retire. The state of Connecticut put together an RFP. I forget the terminology that they used. Every state's been a little bit different. New York did something similar. New York calls it zero emission credits, or ZECs. So they're all a bit different. But ultimately, Mr. Glazier referred to it as a subsidy. People have different reactions to the word subsidy. Ultimately, it is an out-of-market payment. You could call that a subsidy. You could call it a payment for zero emission credits. It is a contract that is going to be paid and compensated outside of the competitive energy capacity markets.
And in your response to Mr. Glazier, you called it payment for a clean energy attribute.
Sure.
There were some questions about fast start capability and dispatchable resources. Is that correct?
Yes.
And you define dispatchable as, quote, able to operate when called upon, unquote.
Correct.
However, isn't it true that under the ISO tariff, the ability to operate when called upon is referred to as unit commitment, and the ability to ramp up and down in response to a signal from the ISO is called dispatchability?
That could be those terms. Sure. I wasn't trying to quote the specific terms in the tariff. I was merely trying to provide a description of how that operates that could be understood by everybody.
And then you explained that there were intermittent resources like wind that were the opposite of dispatchable. Is that correct?
That's correct.
Isn't it a fact, Mr. Hardy, that wind has been fully dispatchable in the ISO real-time market for over 2 years?
I'm not sure how you're defining fully dispatchable, but ultimately, if the wind isn't blowing and the wind is called upon, it can't operate without the wind blow. So I would consider that to be an intermittent resource.
Would it surprise you to know that the ISO considers wind to be a fully dispatchable resource in the real-time market?
I believe the ISO has forecasted wind generation patterns, and they've gotten very good at forecasting those wind generation patterns, subject to they have a pretty good idea what the wind generation profile will look like, and they plan around that. But I would not consider wind to be dispatchable. I would consider it to be an intermittent resource.
Could you read back the pending question, please?
Would it surprise you to know that the ISO considers wind to be a fully dispatchable resource in the real-time market?
Yes.
Would it surprise you to know that the Federal Energy Regulatory Commission, more than 2 years ago, approved ISO New England's request to make wind fully dispatchable in the real-time energy market?
Yes.
If FERC approved ISO New England's request to make wind fully dispatchable in the real-time energy market, would you disagree with FERC about wind being dispatchable?
No, I think maybe where there is some confusion is I tend to think about things from a day-ahead planning market. As you stated earlier, a majority of the energy in New England and in most markets is cleared on a day-ahead basis. So the fact that we're talking about dispatchability in real time, I guess, is probably we're talking about two different things. I'm talking more so from a day-ahead and planning perspective.
In response to a question from Mr. Glazier, you stated that, after the ISO disqualified Invenergy's Turbine 2 from participation in FCA 12, Invenergy was put on critical path scheduling. You recall that?
I'm not sure that I said it was put on critical path scheduling. It was put on critical path scheduling when it cleared FCA 10. Is that what you said?
Well, no. Okay, so
that's what I meant by my answer. I think
okay.
That's what I said.
But we can agree that for the past couple of years, at least, Invenergy has had its attainment of critical path schedule milestones monitored by the ISO.
Since it cleared FCA 10. That's correct.
And critical path schedule is part of the ISO tariff, is that correct?
That's correct.
And subject to check, would you agree that critical path schedule is described in the ISO tariff in section 3.13, point 1, point 1, point 2, point 2, point 2?
Sure.
And would you agree that the ISO describes 8 specific milestones in the tariff as part of the critical path schedule?
I haven't read. I assume that's what you have in front of you. I haven't read in detail the critical path scheduling milestones, so I'm not familiar with the details of it. But
Do you know that the ISO uses that word milestone?
I'm aware of that, yes.
And major permits are a milestone in the critical path schedule?
I would expect that they would be.
Project finance closing is a milestone in the critical path schedule?
Okay.
Major equipment orders are a milestone in the critical path schedule?
Okay.
Do you disagree?
Nope.